case briefs, and so much more. LSData's got what you're looking for.
In a legal showdown against San Francisco Unified School District that reached United States Court of Appeals for the Ninth Circuit in 1998, 3 minors, Brian Ho, Patrick Wong, and Hillary Chen, took a stand, alleging rampant race-based discrimination in education. The case, Ho ex rel. Ho v. San Francisco Unified School District, turned a spotlight on the controversial practice of racial classification and quotas in public schools. The minors flagged that systemic racial categorization had triggered a concerning imbalance. African American and Hispanic students were significantly underrepresented in key academic arenas, notably mathematics, computer studies, and science. Simultaneously, they were disproportionately represented in special education. In essence, the plaintiffs asserted that the district's implementation of its 1983 consent decree was violating the 14th Amendment by breeding racial inequity instead of fostering equality. A key turning point occurred when the district court refuted the defendant's plea to dismiss, ruling that the case could proceed since it addressed issues that had arisen subsequent to the 1983 consent decree. This chain of events led the San Francisco National Association for the Advancement of Colored People, SFNAACP, to also be looped into the litigation as a defendant. Undoubtedly, the crucial message conveyed by the court's ruling was its unequivocal disapproval of the school district's divisive policies. The court declared that racial classification and quotas were problematic, carving a path for a trial to examine the residue of past discriminatory practices and evaluate whether paragraph 13 of the 1983 consent decree was critical to erase these imprints. Highlighting a key argument, the court indicated that it was the government's responsibility to validate the necessity of racial quotas to rectify past discrimination, underscoring that mere good intentions could not sanction such practices. The appeal was ultimately dismissed, and the petition for mandamus denied, marking the end of an enlightening chapter in the quest for educational equality.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.